Hadirin dimohon berdiri.
Ladies and gentlemen, please rise.
Yang Mulia Ketua Mahkamah Agung Republik Indonesia dan Ketua Mahkamah Agung Singapura memasuki ruang acara.
The Honorable Chief Justice of the Supreme Court of Indonesia and the Honorable Chief Justice of the Supreme Court of Singapore enters the auditorium.
Hadirin disilakan duduk kembali.
You may be seated.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Shalom, Om Swastiastu, Namo Buddhaya, salam kebajikan.
Greetings and may peace be upon you. Good morning. Good tidings to us all. Shalom. Om Swastiastu. Namo Buddhaya. Greetings of virtue.
Yang Mulia Ketua Mahkamah Agung Republik Indonesia, Bapak Profesor Dr. H.M. Syarifuddin, SHMH.
The Honorable Chief Justice of the Supreme Court of Indonesia, Mr. Syarifuddin.
Ketua Mahkamah Agung Singapura, The Honorable Sundares Menon beserta para delegasi.
Chief Justice of the Supreme Court of Singapore, the Honorable Sundares Menon, and members of the delegation.
Wakil Ketua Mahkamah Agung Bidang Yudisial, Bapak Dr. Haji Sunarto, SHMH.
Deputy Chief Justice for Judicial Affairs, Mr. Sunarto.
Duta Besar Republik Singapura, His Excellency Kwok Fook Seng, dan perwakilan Kedutaan Besar Singapura.
Ambassador of the Republic of Singapore, His Excellency Kwok Fook Seng, and the representatives of the embassy.
Para Ketua Kamar Mahkamah Agung Republik Indonesia.
Heads of Chambers of the Supreme Court of Indonesia.
Para Hakim Agung dan para Hakim ad hoc pada Mahkamah Agung Republik Indonesia.
Justices and ad hoc judges at the Supreme Court of Indonesia.
Yang terhormat, Panitera dan PLT Sekretaris Mahkamah Agung Republik Indonesia.
The Honorables Registrar and Acting Secretary of the Supreme Court of Indonesia.
Para pejabat Eselon 1 Mahkamah Agung Republik Indonesia.
As well as Echelon 1 officials at the Supreme Court of Indonesia.
Bapak Ibu hadirin yang berbahagia, pada pagi hari yang berbahagia ini kita akan melaksanakan acara penandatanganan Nota Kesepahaman Kerjasama Yudisial antara Mahkamah Agung Republik Indonesia dengan Mahkamah Agung Singapura bertempat di ruang Kusuma Atmaja Mahkamah Agung Republik Indonesia.
Ladies and gentlemen, this morning we are about to conduct the signing of the MOU, marking the cooperation, judicial cooperation between the Supreme Court of Indonesia and the Supreme Court of Singapore, located at the Kusuma Atmaja Auditorium at the Indonesian Supreme Court.
Mengawali seluruh rangkaian acara, menyanyikan lagu kebangsaan Indonesia Raya dan lagu kebangsaan Singapura. Yang mulia dan hadirin kami mohon untuk berdiri.
To start the event, we will sing the national anthem Indonesia Raya and the Singaporean national anthem. His Excellencies, Your Honors, please rise.
Bangsa
Yang mulia dan hadirin, kami silakan duduk kembali.
His Excellency, Your Honors, you may be seated.
Yang mulia dan Bapak Ibu hadirin yang kami hormati, selanjutnya marilah kita saksikan bersama penandatanganan Nota Kesepahaman Kerjasama Yudisial antara Ketua Mahkamah Agung Republik Indonesia dengan Ketua Mahkamah Agung Singapura.
Honorables, ladies and gentlemen, next we will witness together the signing of an MOU, a Memorandum of Understanding of Judicial Cooperation between the Supreme Court of Indonesia and the Supreme Court of Singapore by the Chief Justice of the Supreme Court of Indonesia and the Chief Justice of the Supreme Court of Singapore.
Selanjutnya mohon berkenan Yang Mulia Ketua Mahkamah Agung Republik Indonesia dan Ketua Mahkamah Agung Singapura untuk menuju ke meja penandatanganan.
The Honorable Supreme Court Chief Justice of Indonesia and the Supreme Court Chief Justice of Singapore, you are welcome to take the places.
Penandatanganan dimulai, kami silakan Yang Mulia.
Signing will commence.
Selanjutnya berkenan untuk melaksanakan sesi foto.
Next, a photo opportunity.
Baik, dalam hitungan 3, 2, 1. Sekali lagi. 3, 2, 1. Baik, selanjutnya berkenan untuk melaksanakan penukaran dokumen.
Next, the exchange of documents.
Mohon untuk diabadikan kembali.
Also a photo opportunity.
Baik, selanjutnya berkenan Yang Mulia untuk kami persilakan duduk kembali.
The Honorables, you can go back to your seats.
Yang Mulia, Bapak Ibu hadirin yang kami hormati. Selanjutnya marilah kita dengarkan bersama sambutan Yang Mulia Ketua Mahkamah Agung Republik Indonesia, Bapak Profesor Dr. H.M. Syarifuddin, SHMH, disilahkan.
Honorables, ladies and gentlemen, next we shall listen to the remarks by the Chief Justice of the Supreme Court of Indonesia, Mr. Syarifuddin.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Om Swastiastu, Namo Buddhaya, salam kebajikan. Yang mulia Ketua Mahkamah Agung Singapura, Honorable Sundaris Menon. Yang mulia seluruh delegasi Hakim Agung Supreme Court of Singapura. His Excellency Mr. Kuo Puk Seng, Duta Besar Singapura untuk Indonesia. Yang mulia Wakil Ketua Mahkamah Agung Republik Indonesia, sebentar lagi akan bergabung kembali bersama kita. Yang mulia para Ketua Kamar Mahkamah Agung Republik Indonesia, para Hakim Agung dan Hakim ad hoc pada Mahkamah Agung. Yang kami hormati para pejabat Eselon 1, Bapak dan Ibu dari seluruh pengadilan yang hadir secara online dan hadirin yang saya hormati dan saya muliakan. Chief Justice Sundaris Menon beserta delegasi yang saya muliakan. Selamat datang kembali di Gedung Mahkamah Agung Republik Indonesia. Lantai ini kita namakan dengan ruangan Profesor Dr. Kusuma Atmaja. lantai ini, ruangan ini, biasa kita gunakan kalau kita melakukan pelantikan Hakim Agung atau pelantikan kepala badan tertentu di sini, atau yang Chief Justice pernah hadir, kita juga melakukan annual report di sini, dan kegiatan-kegiatan seremonial yang penting seperti ini. Selamat datang kembali di ruangan ini. Tidak terasa sudah dua kali tahun ini kita bertemu. Pertama di bulan Maret pada saat Yang Mulia beserta delegasi mengunjungi kami. Lalu yang rasanya baru kemarin, kita juga sudah bertemu di akhir Oktober di Kuala Lumpur dalam acara ASEAN Chief Justice Retreat. Saya rasa ini merupakan konsekuensi menjadi negara tetangga dekat yang memiliki banyak kesamaan harapan, banyak kesamaan kepentingan untuk mewujudkan kemakmuran bagi warga di kedua negara maupun kemakmuran bersama di kawasan ASEAN. Saya sangat gembira bahwa pada akhirnya tiba juga saatnya kedua peradilan tertinggi dari kedua negara bersepakat untuk menjalin kolaborasi dari kerjasama yang lebih erat dalam bentuk Nota Kesepahaman atau MOU, kerjasama yudisial yang kita tanda tangani pada pagi hari yang sangat menyenangkan ini. Yang Mulia Chief Justice Menon dan hadirin sekalian yang saya banggakan. Saya yakin bahwa MOU kerjasama yudisial ini merupakan manifestasi kebutuhan bersama kedua negara yang dibangun atas dasar prinsip saling menghormati dalam kesetaraan dan kedaulatan hukum masing-masing jurisdiksi pengadilan. Sebagaimana diketahui, Singapura adalah salah satu mitra dagang penting Indonesia. Beberapa tahun terakhir, Singapura telah menjadi negara dengan nilai investasi langsung tertinggi di Indonesia. Sehingga keberadaan suatu kerjasama yudisial bilateral yang kuat merupakan suatu keniscayaan sebagai pendukung dari kerjasama yudisial multilateral yang sudah terbangun baik melalui forum-forum regional seperti Council of ASEAN Chief Justices. Salah satu titik penting kerjasama yudisial ini adalah kita melakukan pertukaran pengalaman, pelatihan yudisial, serta pembahasan terkait isu-isu yang berkaitan dengan kepentingan bersama sebagai negara bertetangga maupun dalam lingkup regional. Kita dapat berfokus pada isu hukum perdagangan lintas batas, cross-border trade, pengadilan niaga internasional, serta hal-hal yang terkait kerangka kerja internasional untuk keunggulan pengadilan. Saya berharap bahwa MOU dapat lebih memperkuat kerjasama dengan lebih konstruktif dan sistematis. Yang Mulia Chief Justice Sundares Menon dan para hadirin yang saya banggakan. Sebagai bagian dari rangkaian kunjungan Yang Mulia beserta delegasi ke Mahkamah Agung, kita akan menjalani bersama beberapa agenda yang dapat dipandang sebagai implementasi pertama dari MOU kita ini. Kami berharap Yang Mulia dapat memulai dengan berbagai pengalaman terkait mediasi internasional pada pagi hari ini dalam momen sesaat lagi. Kemudian beberapa hal lain terkait penyelesaian sengketa lintas batas dan pengadilan komersial internasional yang akan kita diskusikan dalam 2 hari ini. Kami sampaikan apresiasi dan terima kasih setinggi-tingginya kepada Yang Mulia Chief Justice Sundares Menon beserta seluruh delegasi yang telah hadir di Mahkamah Agung Republik Indonesia. Kita sama-sama berdoa dan berharap persahabatan antara kedua peradilan akan lebih hangat dan kerjasama yang terjalin akan semakin menghasilkan hal-hal yang terbaik untuk kedua peradilan dan bahkan kedua negara. Sebelum saya menutup laporan sambutan ini, saya informasikan kepada Yang Mulia Chief Justice bahwa yang hadir sekarang ada 45 rekan saya Hakim Agung. Ditambah mungkin 9 ya Hakim ad hoc tipikor dan ad hoc PHI, serta pejabat eselon 1. Sekretaris, panitera, dan pejabat eselon 1. Seharusnya kami ini ada 60 orang Hakim Agung. Tapi yang ada hanya 45 ini. Inilah yang pagi hari ini yang akan mendengarkan secara langsung apa yang materi yang akan disampaikan oleh Chief Justice Sundares Menon. Di samping yang mendengarkan langsung, juga ini direlay untuk secara online ke daerah. Mudah-mudahan dapat berlangsung dengan baik dan membawa manfaat bagi kedua negara. Demikian yang dapat saya sampaikan, lebih dan kurang mohon maaf. Wabillahi taufiq wal hidayah. Assalamualaikum warahmatullahi wabarakatuh.
Terima kasih Yang Mulia Ketua Mahkamah Agung Republik Indonesia atas sambutan yang telah disampaikan.
Thank you, Chief Justice of the Supreme Court of Indonesia, for your remarks.
Yang Mulia Bapak Ibu hadirin yang kami hormati, selanjutnya marilah kita dengarkan bersama sambutan Ketua Mahkamah Agung Singapura, The Honorable Sundares Menon, disilakan.
Honorables, ladies and gentlemen, next we shall listen together the remarks by the Chief Justice of the Supreme Court of Singapore, the Honorable Sundares Menon. You have the floor.
Chief Justice Professor Dr. Muhammad Sharifuddin, Vice Chief Justice for Judicial Matters Dr. Sanato, Leadership of the Supreme Court of the Republic of Indonesia, Ambassador Kwok Fook Seng, my fellow judges and colleagues from the Singapore Judiciary, ladies and gentlemen attending in person and online, a very good morning and greetings of peace and friendship. I am delighted to be back in Jakarta for my second visit to the Supreme Court of Indonesia this year, and Chief Justice Sharifuddin and I have already discussed plans for more mutual visits in the first quarter of 2024. Let me begin by thanking Chief Justice Sharifuddin for inviting my delegation to Indonesia. We're deeply honored to be here and are truly grateful to all our friends and colleagues from the Indonesian judiciary for the extensive preparations that were made for our visit and the wonderful hospitality that has been extended to us. As Chief Justice Sharifuddin said in his remarks, we have witnessed a real growth in the relationship between our courts. We have long had a warm and wonderful friendship underpinned by extensive ties between our two countries and our two governments. And today we mark a milestone in the bilateral cooperation between our two judiciaries. The Memorandum of Understanding that Chief Justice Sharifuddin and I have just signed is a landmark instrument which lays a firm foundation for our courts to deepen and to strengthen our ties. Notably, the MOU identifies 4 specific areas for further cooperation, though it is not limited to those areas. And allow me this morning to say just a few words on each of those areas. The first area relates to cross-border commercial law, while the second concerns international commercial courts and international commercial dispute resolution more broadly. The MOU envisions that we will hold conferences and other events to exchange our views and experiences in these two fields. And I'm very pleased to note that we are already making substantial progress on this front. This afternoon, my colleagues, Justice Adit and Justice Mohan, and I will speak on various aspects of transnational commercial law at a seminar on cross-border dispute resolution. Further, the Joint Working Group on Cross-Border Insolvency, co-led by Justice E. Gusti Agung Sumanatha and my colleague, Justice Kanan Ramesh, have begun discussions on organizing a joint training session on cross-border insolvency next year. And as the Chief Justice mentioned, shortly after this, I will deliver a brief address on mediation. I warmly welcome these and similar exchanges which can significantly promote our understanding of the legal framework for international commercial disputes in each other's jurisdictions, and thereby foster collaboration between our courts. The third area for collaboration relates to the International Consortium for Court Excellence and the International Framework for Court Excellence, which the ICCE has developed. The international framework is a valuable tool that courts can use to assess and improve various facets of their systems and their operations, including strategic planning, court infrastructure, and user engagement. I note that several Indonesian district courts have already joined the international consortium and implemented the international framework for court excellence. We would be delighted to work with other Indonesian courts to adopt and apply the international framework and to share our own experiences in using this framework in our operations. The fourth area for collaboration is judicial education and training. I believe this is a central priority for all our courts. We face a range of complex and rapidly developing challenges, and it is vital that we equip our judges with the skills and knowledge that they will need in order to deal with the emerging issues. In this regard, international collaboration will be crucial because we have much to learn from sharing ideas and experiences on many subjects, including substantive law, judicial leadership, and justice systems reforms. I'm therefore looking forward very much to my visit to the Judicial Training Center in Ciawi tomorrow, where I hope to take part in a rich discussion on some important and topical subjects on the future of judging for our courts. Let me conclude by expressing my heartfelt appreciation to a number of our Indonesian colleagues and friends. Justice Takdir Ramadi, who received us and is looking after us very well. Justice Shamsul Marif and Justice Lee Siew Kin, and the teams which they led for all the work that they undertook in bringing this MOU to fruition. This is truly a most worthwhile achievement which will open up many avenues of collaboration, and I have no doubt that it will pave the way to an enduring and vibrant partnership between our judiciaries in the years to come. And finally, let me express my heartfelt appreciation to the Indonesian Supreme Court and the judiciary, led by my friend Chief Justice Professor Dr. Muhammad Sharifuddin, for the extremely warm welcome and the superb program that has been organized for this visit. I also wish to express my deep appreciation for the support and the presence of the justices, the ad hoc judges, and the Echelon 1 officials of the Indonesian Supreme Court, as well as the extensive number of participants who are online as well as in person. It really is a great honor, and I thank you very much. Thank you.
Terima kasih Yang Mulia Ketua Mahkamah Agung Singapura atas sambutan yang telah juga disampaikan.
Thank you so much, Honorable Sundaras Menon, Chief Justice of the Supreme Court of Singapore, for your remarks.
Yang Mulia dan Bapak Ibu hadirin yang kami hormati, acara penandatanganan Nota Kesepahaman Kerja sama Yudisial antara Ketua Mahkamah Agung Republik Indonesia dan Ketua Mahkamah Agung Singapura telah selesai. Selanjutnya berkenan Yang Mulia Ketua Mahkamah Agung Republik Indonesia dan Yang Mulia Ketua Mahkamah Agung Singapura untuk kembali ke tempat semula.
Honorables, ladies and gentlemen, the signing ceremony of the Memorandum of Understanding has been concluded. We would like to invite now the Honorable Chief Justices to go back to their seats.
Yang mulia Bapak Ibu hadirin yang kami hormati. Selanjutnya marilah kita ikuti bersama ceramah umum mengenai international mediation, dilanjutkan diskusi yang akan disampaikan oleh Ketua Mahkamah Agung Singapura, The Honorable Sundares Menon.
Honorables and ladies and gentlemen, now let us listen to the public lecture on international mediation, followed by a discussion, which will begin by a presentation by the Honorable Chief Justice of the Supreme Court of Singapore, Sundares Menon.
Untuk itu kami mengundang Yang Mulia Bapak Syamsul Ma'arif SH LLM PhD, Hakim Agung Kamar Perdata Mahkamah Agung Republik Indonesia selaku moderator untuk menempati tempat yang telah ditentukan.
For that purpose, we would like to invite the Honorable Justice Syamsul Ma'arif, Justice at the Civil Chamber of the Indonesian Supreme Court, to take his place as the moderator.
Selanjutnya kami silahkan Yang Mulia Bapak Syamsul Ma'arif SH LLM PhD selaku moderator untuk memimpin sesi ceramah umum dan diskusi.
Next, we will invite Justice Syamsul Ma'arif to lead the session as the moderator.
Thank you very much. Yang Mulia Ketua Mahkamah Agung Republik Indonesia, Profesor Dr. Muhammad Syarifuddin, the Honorable Justice Sundares Menon, Supreme Court of Singapore, Yang Mulia Wakil Ketua Mahkamah Agung Bidang Yudisial, Bapak Sunarto, the Honorable Justice Singapore, I saw that Justice Lee, Justice Pang, and Justice Abdullah, yeah. The Honorable Ambassador Kwok Fuk Seng, thank you for coming. Ladies and gentlemen, and of course the Honorable Justice of Supreme Court of Indonesia, very good morning. Assalamualaikum warahmatullahi wabarakatuh. My name is Syamsul Ma'arif, and it's my pleasure and honor to be a moderator for this session. Bapak Ibu hadirin sekalian, sebelum lecture dimulai, barangkali perlu saya berikan beberapa catatan. Penyelesaian sengketa alternatif ini sudah menjadi topik yang hangat di berbagai belahan dunia. Secara formal, artinya melalui pengadilan, sengketa kita selesaikan. Tetapi nampaknya banyak hal yang perlu diperbaiki sehingga perlu ada namanya penyelesaian sengketa alternatif. Salah satu diantaranya adalah mediasi. Banyak negara yang sudah secara khusus mengembangkan dan menawarkan keunggulan penyelesaian sengketa alternatif. Mereka berusaha agar penyelesaian sengketa alternatif ini lebih efektif ke depan. Kepopuleran penyelesaian sengketa alternatif juga sudah mendorong banyak negara untuk memodifikasi prosedur, termasuk diantaranya adalah sengketa lintas batas negara yang tadi sudah disebutkan oleh Chief Justice Menon. Salah satu contohnya adalah ini upaya untuk mencari penyelesaian sengketa yang lebih efektif di sengketa internasional. Salah satu diantaranya adalah pengadilan komersial. Tadi sudah disebutkan oleh Chief Justice Menon bahwa ini topik yang beliau sampaikan pada lecture beberapa waktu yang lalu. Pengamatan saya secara pribadi semakin banyak negara yang sekarang punya namanya pengadilan komersial internasional. Jadi ada semacam persaingan antara pengadilan komersial internasional dengan arbitrase internasional. Dua-duanya membutuhkan tenaga yang sangat profesional dan ahli di bidang penyelesaian sengketa internasional melalui alternatif, tidak melalui pengadilan. Satu di antaranya adalah United Nations Conventions on Recognition and Enforcement of Foreign Arbitral Awards atau dikenal dengan New York Convention. Yang kedua, yang nanti akan kita dengar dari pidatonya Chief Justice Menon adalah tentang United Nations Conventions on International Settlement Agreement resulting from mediations atau lebih dikenal dengan Singapore Conventions on Mediations. Ini nanti akan kita dengar dari beliau. Ceramah pagi ini akan membahas mediasi sebagai tren terkini dan peran pengadilan untuk mengoptimalkan mediasi. Sebelum Chief Justice Menon memberikan presentasi, barangkali izinkan saya untuk memperkenalkan beliau, meskipun saya yakin semua di antara kita sudah kenal dengan beliau. Ini hanya sekedar mengupdate saja ya. Kesan saya pribadi, beliau ini orang yang memang pengalamannya sangat komprehensif ya. Beliau lulus dari Universitas National University of Singapore, Bachelor of Law dengan title First Class Honor. Setahu saya First Class Honor itu kalau di Singapura, correct me if I'm wrong, First Class itu artinya dia lulus dengan nilai tertinggi, bukan hanya dari universitas ya, tapi dia nilai tertinggi dari seluruh universitas di Singapura. Itu First Class Honor. Kemudian beliau dapatkan LLM dari one of the best law school in the world, yaitu Harvard Law School. Beliau punya pengalaman sebagai pengacara, sempat berpraktek di Singapura dan juga berpraktek di New York. Bahkan beliau sempat menjadi anggota Komisi Yudisial, kalau di sini istilahnya KY. Kemudian beliau juga sempat diangkat sebagai Jaksa Agung ke-6 Singapura. Dan sejak tahun 2012 beliau diangkat sebagai Ketua Mahkamah Agung. Di bidang penyelesaian sengketa komersial internasional, beliau juga he is the guy. Antara tahun 2012 sampai dengan 2020, Chief Justice Menon juga bertugas sebagai Governing Board of International Council for Commercial Arbitrations. Beliau juga telah menjabat sebagai anggota International Chamber of Commerce Governing Body of Dispute Resolution Service sejak tahun 2021. Jadi beliau sempat sebagai jaksa, sempat sebagai advokat, praktisi, ngajar di mana-mana, dan kini sebagai Ketua Mahkamah Agung. Bapak Ibu sekalian, materi pidato Chief Justice pada pagi hari ini sangat penting dan barangkali sebagian besar kita sudah pernah mendengar, tetapi kita ingin mendengar langsung dari pelaku sejarahnya. Karena apa? Karena konvensi yang kita bicarakan ini judulnya saja Singapore Conventions on Mediation. Jadi kita ingin dengar langsung dari pelaku sejarahnya. Idealnya presentasi ini bisa diberikan dalam waktu paling tidak 2 jam, paling tidak. Tapi karena agendanya sangat banyak, sehingga kita harus mengakhiri pertemuan ini paling lama jam 11.30. Tapi tentu nanti mohon izin Chief Justice, kita akan adakan sesi tanya jawab sebelum 11.30. Ladies and gentlemen, without further ado, please welcome Chief Justice Sundares Menon.
Thank you very much, Justice Shamsul, for those very kind and generous remarks. Chief Justice Professor Dr. Muhammad Sharifuddin, Vice Chief Justice for Judicial Matters Dr. Sunato, leadership of the Supreme Court of the Republic of Indonesia, ladies and gentlemen, a very good morning once again. Let me begin by thanking the Indonesian Supreme Court for inviting me to address you on the subject of international mediation. International mediation is an area of growing importance and interest, and I'm very pleased to have the opportunity to share my perspectives with you this morning. And as Justice Shamsul said, at the end of my address, we'll be happy to take questions and to have a moderated discussion. My thesis this morning can be summarized as follows. Mediation is a fundamentally important tool for the resolution of disputes because it advances two core ideals of our justice systems. The first is the rule of law, and the second is the maintenance of peace. In the international domain, mediation has shown immense potential in terms of advancing the amicable resolution of at least two main types of disputes. First, international family disputes, and second, international commercial disputes. But the promise of international mediation can only be realized fully if it is supported by the courts. Our judiciaries have a central role to play in promoting international mediation and in facilitating its integration into the wider system of transnational dispute resolution. And I suggest this morning that all of us, judges, should earnestly pursue this endeavor because this will be vital to enhancing the appropriate and efficient settlement of disputes on the international plane. I will divide my remarks this morning into three main parts. First, I will sketch the historical roots of mediation in our societies and its recent rise to prominence in formal dispute resolution. And I will address how mediation advances the rule of law and the preservation of peace, and I will illustrate these benefits by reference to the reforms that we in Singapore have implemented in the area of family justice. The second part of my speech will focus on international family justice. I will touch on the use and the value of mediation in this context and offer some suggestions about how our courts should try to foster and promote international family mediation. And in the last part of my address, I will turn to international commercial mediation. I will explain the pressing need for this mechanism in the resolution of international disputes, and I will explain the significance of the Singapore Convention on Mediation before outlining the role of the courts in advancing international commercial mediation. So let me begin with an overview of the roots of mediation in our communities. Historically, traditional forms of mediation have been prevalent in Asian societies, and it is something that all of us are familiar with. For example, in the early years of Singapore's history, disputes between Chinese merchants were often mediated at Chinese clan associations. Similarly, in Singapore, Malay villagers would take their disagreements to their headmen for amicable settlement. And Indian communities relied on what was known as the panchayat, or community councils, to resolve disputes peaceably. And in Indonesia, commentators have suggested that mediation resembles long-established practices of musyawarah mufakat, under which disputing parties enter into negotiations often facilitated by a community leader to reach an acceptable outcome that preserves harmony. Yet despite this long history of informal mediation being very much a part of our societies, mediation did not play a significant role in formal dispute resolution in many Asian societies until quite recently. In Singapore, the rise of mediation in our legal system began in the mid-1990s with the introduction of court-annexed mediation. This was in 1994. And in 1997, the Singapore Mediation Center was formed, and in 1998, the community mediation centers were launched. It is interesting to note that the rise of the mediation movement in Indonesia has been traced to roughly the same period, and it has been suggested that two key milestones in this journey were the passage of the law governing alternative dispute resolution in 1999 and the introduction of court-annexed mediation in 2003. But why did mediation not play a more prominent role in our legal systems for so long, despite their historical affinity within our ethnic cultures? In relation to Singapore, several reasons have been identified, including urbanization, which led to the dispersion of the traditional communities that practiced mediation, and a growing awareness of legal rights that led more people to assert their rights and to litigate their disputes. But beyond these factors, I suggest that mediation was for so long absent from our modern legal systems because these had been shaped to a large extent by our colonial histories, and because it was seen as alien or even antithetical to the ideals of those colonial legal systems. In particular, it was seen as inconsistent with the rule of law because the rule of law was viewed as inextricably linked to judicial adjudication and decision-making. And it was understood to require the public determination of disputes in accordance with the parties' legal rights. Mediation as a private form of dispute resolution that focused on the parties' interests, not their rights, their interests, was therefore thought to be contrary to this fundamental ideal. I suggest that this view stems from an unduly narrow conception of the rule of law, and that this unduly narrow conception is no longer appropriate today. In its place, we should adopt a broader vision of the rule of law that, of course, embraces adjudication, but at the same time also places significant weight on the value of securing access to justice and on the maintenance of peace. If the rule of law is to capture the ideals of a legal system, then access to justice must be an integral part of that concept, because the very point of a justice system is to deliver justice. And having even the most principled, sophisticated, and established legal system would be worth nothing if it cannot be accessed by the people who need it. Indeed, I suggest that securing effective access to justice must be a key priority for judiciaries today because of the realities that confront those who seek to use our court systems. And they are faced with issues like the spiraling cost of litigation, the limited amount of judicial resources, and the technical nature of legal procedures, all of which combine to present formidable obstacles to these litigants. It is therefore critical that we reimagine the rule of law to reflect the central importance of securing access to justice. And once we adopt this broader conception of the rule of law, it becomes plain that mediation will play a vital role in helping us to achieve this important ideal. And this is so for a number of reasons. First, mediation is a much more affordable and speedy mode of dispute resolution than litigation or arbitration. For example, over 67% of cases, more than 2/3 of the cases filed at the Singapore Mediation Center are settled. And more than 90% of these are resolved within just 1 day. This underscores the importance and the potential of mediation to help parties secure remedies and outcomes for their grievances in a cost-efficient and timely way. Second, mediation is far more intelligible and understood and meaningful to its users than litigation, because mediation is relatively informal and untechnical. And the processes of mediation focus on the needs and interests of the parties rather than on legal concepts and doctrines that are often foreign to lay people. Mediation is an efficient and practical solution for many disputes, and it therefore promotes access to justice and the rule of law. And this leads me to the second point I suggested, which is that mediation serves a second core ideal of our legal systems, and that is the maintenance of peace. Some 45 years ago, Sir Jack Jacob, an eminent English lawyer, contended that the resolution of disputes was vital to promote peace and harmony in society, lest they fester and breed discontent and disturbance. The point he was making was, if you don't have peace, over time society will break down. This captures a key insight into the function of the justice system, which is to play a critical role in reducing conflict and maintaining harmony, and in that way sustaining peace in our societies. And mediation is uniquely suited to advancing this peace-building role of our justice systems. First, unlike the adversarial and zero-sum nature of litigation, by zero-sum I mean you have a winner and a loser. You don't have both parties going forward with an acceptable way. It is one party wins, one party loses, and the sum is zero. Unlike the adversarial and zero-sum nature of litigation, mediation focuses on achieving an amicable settlement, a resolution that serves the interests of all the parties. Hence, it is more likely to achieve an outcome that preserves the relationships between the parties. And second, because mediation is attuned to the needs and the interests of the parties, it is more likely to get to the heart of the dispute. It can therefore give rise to a more holistic and enduring solution to the underlying sources of conflict in comparison to adjudicative forms of dispute resolution. Let me illustrate these points about mediation by reference to our experience, the Singapore experience in family justice. Over the last few decades, mediation has become a key part of our family justice system. Our journey began in 1996 when voluntary court-annexed mediation was introduced for family justice. In 2011, the law was amended to mandate divorcing couples with minor children to undergo mediation. And then in 2014, mandatory mediation was extended to all family cases that involved children who were under the age of 21. And the court was empowered to direct parties at any time to undergo mediation. These developments culminated in 2020 when we adopted the philosophy of therapeutic justice, healing justice, as the guiding ethos and principle for our family justice system. In essence, this calls for family justice to be holistic, in that it must address not only the legal issues between the parties, but also their underlying non-legal causes. It must be restorative in the sense that it must help to repair the relationships between the parties. And that doesn't mean that we will prevent divorce. Sometimes parties will continue and get their divorce, but at least they can work together for the sake of their children. Because even if they're no longer husband and wife, they're still mother and father. They're bound by these ties. And it must be forward-looking in encouraging the parties to focus on together creating a mutually acceptable future. In a sense, therapeutic justice reflects the spirit of mediation, and our adoption of that ethos reflects the central place of mediation in our family justice system. Mediation has come to play the central role in family justice in Singapore because it has brought the two key advantages and benefits that I mentioned earlier. First, mediation has significantly enhanced access to justice in family disputes. Studies have found that more than 75% of the cases mediated by our family courts led to either a full or partial settlement. And this indicates that mediation has brought substantial time and cost savings for the parties involved in family proceedings. And this is also borne out by the feedback that is given to us by family court users who have praised mediation as a cost-efficient and highly practical solution. And second, mediation has made a crucial contribution to the promotion of peace in the family context. A recent study of almost 2,000 divorce cases in Singapore found that mediated cases involving children were substantially less likely to be re-litigated than cases resolved through litigation or even negotiations. And significantly, this finding that it was less likely to be reopened or re-litigated held true for up to 3 years after the original dispute was first determined. This suggests that mediation has made a real difference to preserving ties and minimizing conflict between the parties to family proceedings. So we have seen mediation to be an essential and invaluable tool for dispute resolution because it has advanced the rule of law by enhancing access to justice, and it has built up the peace-building function of our justice systems. And these benefits are equally applicable to international disputes as they are to domestic disputes, which suggests that mediation should also play a central role in the resolution of transnational disputes. And that brings me to the subject of international mediation, the value it can offer, and the role of the courts in supporting this mechanism. And again, I want to begin with international family mediation. And let me begin by explaining the need for the tool of mediation in the context of international family disputes. We all recognize that globalization over the last few decades has without question accelerated the movement of people across national borders. And this has led to a steady rise in the number of what I call international families, which has been accompanied by a sharp increase in marriages in distress, troubled marriages involving spouses of different nationalities. The result has been a tremendous growth of cross-border family disputes, such as disputes involving international child abduction and international relocation, when one parent in a distressed family wants to take the child and move back to his or her home jurisdictions. And these disputes are complex and challenging, especially when children are involved, because the decisions tend to be binary. It is either the parent has to stay or the child has to stay. There's very little middle ground. And such decisions have profound implications for the parties and their children as they contemplate their future. Historically, it was thought that mediation had little part to play in cross-border family disputes. There were doubts about how mediation would fit in or cohere with legal frameworks like the Child Abduction Convention. And practical concerns such as the challenges of mediating disputes that would often involve parties of different nationalities, different cultures, and even different languages. But over the last 20 years, international family mediation has proven to be a highly effective tool for the resolution of international family disputes. Studies have found that mediation has played a critical role in containing such disputes, limiting them, and in helping to preserve family ties. For example, a 2006 study found that 75% of mediations in cases of international child abduction that was conducted by Reunite, which is a charity based in the United Kingdom, led to an agreement between the parties that generally resulted in a consent court order concerning the child's residence. And a follow-up study that was done in 2012 found that in cases where a consent order was made post-mediation, in other words, as a result of the mediation, the parties generally avoided further litigation, and both parents generally kept on positive terms and were able to work out issues for the benefit of their children. And let me just pause to say that this is precisely in line with our own experience of the 2000 cases that I referred to earlier on. So these findings again underscore and underline the two main benefits of mediation which I've already spoken of, namely its vast potential to enhance access to justice and the major contribution it makes to the preservation and promotion of peace between the disputing parties. Now, it is important to note that mediation should not be seen as a substitute for legal regimes such as the Child Abduction Convention or even for litigation. But the value of mediation lies in offering a powerful source of support to the legal frameworks and court processes by providing the parties to these disputes to take a step back from acrimonious litigation, to think again about the best interests of their children, and to try to re-establish the ability to co-parent together. Now, this suggests a need to establish linkages between international family mediation and other modes of dispute resolution in order to advance the integration of mediation into the broader system of transnational family justice. And that brings me to the role of the courts. And I suggest that our courts can support international family mediation both in the context of the work we do in the judicial setting as well as the work we do in the extrajudicial setting. In the judicial setting, the courts can send the appropriate cases to international family mediation and develop the related practice directions, rules, guidance that would facilitate this. Thus, our family justice courts have issued a practice direction providing for the court in appropriate cases to refer international child abduction disputes to private mediation providers like the Singapore Mediation Center. And similarly, the President of the Family Division of the High Court of England and Wales has issued practice directions and guidance on the mediation of international child abduction cases, which I will refer to as the Family Division Practice Guidance. These protocols can promote international family mediation in at least 3 ways. First, they raise awareness of the nature of international family mediation. And this is useful because without doing that, the parties and their lawyers might not otherwise be familiar that this is an available avenue for the resolution of their disputes. Among other issues, practice guidance can identify the relevant mediation service providers and clarify the process of mediation so that people have a good understanding of what to expect. Second, court protocols on international family mediation can help to enhance the credibility of such procedures by giving the judicial stamp of approval to these mechanisms. So the parties come to trust these mechanisms as reliable ways to resolve their disputes. And third, and crucially, court guidance can clarify the interface between the mediation and the litigation processes, which will often run in parallel. For example, the English Family Division Practice Guidance provides that the court may make directions on a timetable for the mediation to ensure that it concludes within the expedited timelines for the resolution of international child abduction proceedings. And it also provides for the court to direct in appropriate cases that the child be interviewed for the purpose of the mediation. Such protocols play a critical part in ensuring that mediation and litigation operate seamlessly to secure the coherent and efficient resolution of these disputes. And turning to the extrajudicial setting, family courts can advance international family mediation in at least 2 ways. First, our courts can collaborate to develop agreed instruments to enhance and strengthen international family mediation. And let me here highlight the work of the Council of ASEAN Chief Justices Working Group on Cross-Border Disputes Involving Children that has made substantial progress. In 2021, the working group adopted a non-binding protocol, and this provides for communication between points of liaison to arrange the mediation of such disputes where cross-border disputes involving children arise within the ASEAN region. The points of liaison may ascertain whether the parties will agree to mediation, and if so, they will facilitate arrangements for mediation. Such instruments can greatly facilitate the smooth conduct of international family mediation. The working group has also issued a non-binding code of ethics for mediators, which sets out the aspired values and minimum standards for mediation of cross-border disputes involving children within the ASEAN region. And this will help advance the ongoing project of articulating the key principles and the best practices for international family mediation, which is essential if we are going to secure the quality and legitimacy of this mechanism. And second, our courts can collaborate with mediation organizations to help deliver relevant training to family courts and mediators. Our family justice courts have collaborated with the Law Society of Singapore, the Singapore Mediation Center, the MIKK International Mediation Center for Family Conflict and Child Abduction, which is a leading international family mediation provider, all to deliver training in cross-border family mediation to SMC's family mediators. So you see, in these ways, our courts can both foster international family mediation and advance its integration into the broader system of transnational family justice. And I suggest our courts should play a similar role in supporting international commercial mediation, which brings me to the third and final part of my address this morning. Let me set the stage by explaining the need for international commercial mediation. Today, arbitration and litigation remain the predominant mechanisms for the resolution of international commercial disputes. But I suggest that it is time for international commercial mediation to come to the fore, given the challenges that plague the adjudicative modes of dispute resolution, such as litigation and arbitration, and the inherent suitability of mediation to certain types of commercial disputes. International commercial arbitration and litigation face several significant problems. The most prominent issue is the escalating cost and time associated with these mechanisms. Multiple studies have found that cost is the worst trait of international arbitration, with costs awards in the largest cases often exceeding $10 million US. And this can also be true of major transnational litigation. For example, the cost of litigation incurred by Fortune 500 companies have been estimated at as much as 1/3 of their after-tax profits. And apart from cost, lack of speed is a critical challenge. According to Professor Gary Bourne, a leading arbitrator, it can take 18 to 36 months for a final award to be issued in a major international commercial arbitration. And then such disputes will take a similar length of time to go through the court process before the award can be enforced. The costs and delays entailed by arbitration and litigation are now being compounded by a new, developing, and even deeper problem. And this is what I have referred to as the complexification of disputes. This refers to the growing complexity of disputes, which has two aspects. The first is technical complexity, and by technical complexity I refer to the increasing technical nature of the evidence and the issues that frequently arise in major commercial disputes. This flows from advances in science and technology, which are increasing the number and the sophistication of technical concepts and methods that are deployed in every field of commercial litigation, and therefore places greater demands on the intricacy and the range of the technical issues that the arbitrators will have to deal with. And then there is what I call evidential complexity, but this is just referring to the dramatic increase in the amount of documents and evidence because of the widespread use of technology, and the consequent explosion in the amount of data and documents that are created, stored, and then produced as evidence. The rise of complexification has serious implications for the adjudication of international commercial disputes. At the first level, it suggests that international commercial arbitration and litigation will become even more expensive and even more protracted to resolve unless new and innovative measures are introduced to contain, to reduce them, to downsize these disputes. But complexification also threatens the quality of adjudicative decisions because there is simply a limit to how much information anyone can process. And more broadly, the increasing number of these complex cases places an increasingly unsustainable burden on our adjudicative systems because they take up a disproportionate share of limited adjudicative resources. In contrast to arbitration and litigation, international commercial mediation is a much more affordable and a much speedier mode of dispute resolution. And it is less plagued by the problem of complexification because it does not require an exhaustive search for the truth and the painstaking determination of the parties' rights. The focus is on their interests, and you don't need a lot of money and a lot of evidence to understand what those interests are. For these reasons, international commercial mediation is a highly accessible tool for the resolution of cross-border commercial disputes. And it is a particularly suitable tool for resolving certain types of commercial disputes. It is especially valuable in a setting where there is a vital need to preserve the relationship between the parties, and where a binary win-loss outcome is not appropriate. Take, for example, disputes that arise frequently between the owner and the main contractor during a complex construction project. In such a setting, which will entail a project that's going to take many years with high stakes for both parties, it will be crucial to sustain the relationships between the parties to ensure the successful completion of the project. Further, a win-loss result may be unsuitable for certain disputes that arise from unforeseen events, such as the outbreak of a pandemic, something we've all encountered in the recent years. Mediation is the ideal mode of dispute resolution for these kinds of disputes because, as I noted earlier, it strives to achieve an amicable resolution that preserves the bonds between the parties and focuses on advancing their shared interests rather than insisting upon their strict legal rights. So why, if this is true, why is it that mediation has stood in the shadow of arbitration and litigation for so long? And I suggest there are several reasons for this, but one factor stands out, and that is the lack of enforcement mechanisms that apply to settlement agreements that result from international commercial mediation. In a 2014 survey conducted by the International Mediation Institute, more than 90% of respondents said the absence of an international enforcement mechanism for mediated settlements was a major impediment to international mediation. Similarly, a 2019 study commissioned by the Singapore Academy of Law found that only 5% of respondents considered mediation to be their preferred means of resolving international commercial disputes, with enforceability being the key factor in their choice of a dispute resolution mechanism. Let me just take a minute to explain why this is so. Because the parties go through the process and the effort to mediate their dispute, to come to an agreement, and may find when they try to enforce the agreement that the party breaches the agreement, they're back to square one. They have to start the action all over again. That was the biggest problem why parties were not willing to say that their international commercial disputes will be resolved through mediation. The interesting thing is, the same concern had once plagued international commercial arbitration. Because there was a time before the New York Convention when you had an award and it didn't necessarily translate into effective enforcement. But these concerns have long faded away because of the almost universal adoption of the New York Convention. And today, arbitration's growth over the last 3 decades can be traced to that. The success of that instrument shows that a multilateral enforcement regime can decisively resolve issues of enforceability. And that is why I believe that the Singapore Convention on Mediation, which was modeled on the New York Convention, is a watershed, a milestone in the development of international commercial mediation. Let me very briefly summarize the framework of the Singapore Convention. The Convention governs settlement agreements that are the result of the mediation of a commercial dispute. And these must be disputes that are international in nature, based on the place of business of the parties or the content of the settlement agreement. If you qualify, the Convention establishes an enforcement regime that is premised or rests on 2 main provisions. First, Article 3 imposes a duty on all parties to the Convention, the states that are party to the Convention, to enforce international commercial mediated settlement agreements and to grant preclusive effect to such agreements. What does that mean? It means that these agreements can be used as a sword to secure compliance with the agreed obligations and to prevent those issues from being re-litigated in the courts. Once you've settled it, your rights are limited to the agreement, and that agreement can be treated as the equivalent of a judgment of the court. That's how it operates. And the second key provision is Article 5. Article 5 sets out an exhaustive and limited set of grounds on which the parties may challenge the enforcement of settlement agreements that come within the scope of the Convention. And these grounds mostly mirror or are similar to the grounds found in the New York Convention for invalidating or resisting enforcement of an arbitration award. And you all know how difficult it is to resist enforcement of an award. You have to show grounds such as the incapacity of a party, or the nullity or the inoperability of the award. Similarly, in our context, the nullity or inoperability of a settlement agreement. And the or you can show that it's contrary to the public policy of the state in which enforcement is sought. It's very narrow grounds that we're all familiar with because they're similar to the grounds in the New York Convention. But there are a couple of grounds specific to mediation. For example, enforcement may be refused if the obligations in a settlement agreement are not clear or comprehensible. And this has been discussed in the commentaries, and the prevailing view, I think, is that it has very limited scope. Or if the mediator committed a serious breach of mediation standards, and if not for that breach, the parties would not have entered into the agreement. That is something that we in the courts will have to pronounce on in due course. So the Singapore Convention establishes a careful, calibrated regime for the enforcement of international commercial mediated settlement agreements. And it'll now fall on us, the enforcement courts, to develop and uphold this framework and give meaning to it, which I will come back to in a moment. But apart from resolving the problem of enforceability, the Singapore Convention has also enhanced the credibility, the legitimacy of mediation in the international commercial context. For many years, mediation was hampered by the absence of a multilateral treaty that could serve as a trust mark of legitimacy for parties who were thinking of mediation to resolve their disputes. And the Singapore Convention is likely to have the effect of promoting the legitimacy of international commercial mediation because of its embrace by the international community. So I suggest that the future of international commercial mediation looks bright. But it will only thrive if mediation is supported by other key players in what I have referred to as the transnational system of commercial justice, and is well integrated into that system. The success of international commercial mediation will turn on the appropriate application and development of the enforcement regime that is provided under the Singapore Convention. And this will be done by the courts and other dispute resolution bodies, including courts and arbitration, must see mediation not as a competitor, but as a partner in the international enterprise for the resolution of commercial disputes. So, it is vital that all of us and others who are stakeholders in the transnational system, that we come together to support and sustain international commercial mediation, because it is such a valuable part of the means at our disposal to advance the commercial rule of law. And commercial courts have a particular role to play because they are the supervising courts in the transnational system of commercial justice, who oversee and steer the development of the system. And let me close by suggesting 3 ways in which the courts do this. First, it is for us to develop the law and the principles governing the practice of international commercial mediation. In particular, in deciding disputes over the grounds related to mediator conduct in Article 5 of the Singapore Convention, the courts will have to concretize and shape mediation standards. And let me draw an example from what we have all done in relation to arbitration when we deal with standards or challenges based on natural justice. It is the courts that define what that standard requires in terms of acceptable arbitration conduct. Similarly, in this context, the courts will develop international commercial mediation by articulating principles that are sensitive to the realities of contemporary mediation practice and that reflect core ideals such as confidentiality and independence. And apart from mediation standards, the courts will also promote the enforcement regime under the Singapore Convention by interpreting the other grounds in Article 5 appropriately. I think, in general, the courts, when faced with challenges, will look at the case law that has already emerged in the context of arbitration. I think that's reasonable to infer. But there will be other provisions. For example, it has been suggested that the concept of the obligations in a settlement agreement being not clear or comprehensible should be interpreted narrowly to reduce the risk of abuse by those seeking to resist enforcement of mediated international commercial settlement agreements. Second, I think commercial courts can promote linkages between international commercial mediation and litigation by working with mediation bodies to develop composite integrated dispute resolution models and frameworks. And let me give you an example. In January this year, the Singapore International Commercial Court, or the SICC, and the Singapore International Mediation Center, or the SIMC, launched a mediation protocol. And under this protocol, proceedings filed in the SICC may be referred to mediation at the SIMC. The SICC will support such mediation by granting a case management stay of the proceedings. And if the mediation succeeds, the SICC will record the terms of the settlement as an order of court to facilitate its enforcement. And even if the dispute settles in part, then what remains can come back to the SICC for resolution. This is a great example of how the courts can promote international commercial mediation by integrating it with the other arms of the transnational system for commercial justice. And finally, commercial courts can drive dialogue between the providers of international commercial mediation and other dispute resolution bodies. For example, the Standing International Forum of Commercial Courts, of which I'm a member of the steering group, invited leading arbitrators and mediators to attend and contribute to its fourth full meeting last year. And at the meeting, we discussed a number of important issues such as the complexification of disputes, how to foster the integration of the transnational system of commercial justice, and so on. Such dialogue can advance international commercial mediation by raising awareness of its nuances, of its issues among judges and arbitrators, and by helping to generate ideas about how different dispute resolution bodies can collaborate to address the common challenges and so advance the coherent and efficient operation of the transnational system. Ladies and gentlemen, international mediation has had a long and somewhat vexed gestation, but it has overcome doubts and difficulties and has now emerged as an essential tool for the resolution of cross-border disputes. And it is now incumbent on us, courts and judges, to usher in this fast developing mechanism and to integrate it into the broader frameworks of transnational dispute resolution so that we may advance the fundamental ideals of our justice systems. And we in Singapore look forward to working with you, our dear friends in Indonesia, in this quest. Thank you very much. Thank you, Father.
Thank you very much for the excellent speech and full with inspiring thought. We have about 30 minutes, Now it's open for question and answer. Tapi sebelum itu barangkali saya sampaikan beberapa summary singkat. Chief Justice Sundaris Menon sudah menyampaikan pentingnya mediasi sebagai cara untuk melengkapi penyelesaian sengketa yang secara konvensional dilakukan oleh pengadilan maupun oleh arbitrase. Mediasi ini relevan untuk menyelesaikan baik sengketa family domestik maupun internasional. Selain tentu saja juga relevan untuk menyelesaikan sengketa komersial internasional. Banyak positifnya mediasi dibandingkan dengan arbitrase. Kita juga di antara kita sudah aware itu, tapi tadi Chief Justice memberikan penekanan. Dibandingkan dengan arbitrase, mediasi tentu lebih ringan biayanya. Salah satu kendala arbitrase adalah persoalan biaya. Takes a cost, a lot of cost. Dari segi waktu juga takes a lot of time. Tapi mediasi ini menjadi alternatif yang dari segi biaya juga rendah, dari segi waktu juga rendah. The good thing lagi adalah bahwa mediasi ini working for the interest of the party, untuk kepentingan pihak. Memang saya kira kita juga mengalami beberapa sengketa misalnya utang piutang ya. Secara hukum harus diselesaikan berdasarkan 1320. Lihat perjanjiannya, ada nggak klausula pandemi kan gitu. Banyak di antara kita menghadapi kasus debitor ini nggak mampu apa-apa bukan karena dia ingin nggak bayar, tapi karena memang pandemi. Tapi karena di kontrak tidak ada klausula itu, akhirnya ya secara hukum debitor harus bayar kan gitu. Sehingga mungkin ini menjadi contoh konkret. Andai itu diselesaikan melalui mediasi, maka kepentingan kedua pihak itu akan terpenuhi. Ini salah satu contoh the good things buat mediasi. Tentu saja mediasi juga bisa dipakai di internasional, ya. Baik family dispute di international family maupun di international commercial dispute. Sekali lagi bahwa presentasinya ini bukan hanya untuk sengketa komersial, tapi juga family. Ada data yang tadi disampaikan, the success story of mediation di Singapura dan di beberapa negara. Lebih dari 70% sengketa family selesai melalui mediasi. Dan mayoritas mereka setelah selesai melalui mediasi tidak lagi ke pengadilan. Nah ini barangkali contoh yang bisa kita ambil. Mungkin nanti Ketua Kamar Agama mungkin bisa sharing ya. Seberapa banyak data sengketa keluarga kita bisa selesai melalui mediasi, dan apakah setelah selesai mediasi mereka sengketa lagi sampai ke pengadilan atau udah seterusnya akan peace kan. Jadi bukan hanya komersial topiknya tapi juga keluarga ya. Jadi mungkin ini tema yang menurut kami penting untuk kita sharing ya. Tanpa perpanjang komentar saya persilakan jika ada pertanyaan atau klarifikasi dari para yang mulia. Jika dari pimpinan ada yang memulai, dipersilakan ya. Prof. Takdir, silakan Prof.
Thank you, Mr. Moderator and Chief Justice Sundaris Menon. Thank you for your lecture that has given us broader knowledge about mediation practices in Singapore and in other regions. Right, as you mentioned, mediation practice actually has deep-rooted in the ASEAN values. Indonesian people also believe that. But when we compare with the empirical fact or data, as you mentioned also, Supreme Court since 2003, and then the regulation 2003 has been revised twice, 2008, and the last one, which now is still in force, is Supreme Court Regulation number 2, 2018. And even Supreme Court, since 4 years ago, has launched a program by giving reward to successful mediators, both judges and non-judges. Because under our system, mediator can be practiced by judges or non-judges. But in reality, and mediation apply in two types of court, general court and Sharia or religious court for family matters among the Muslims. But the data mentioned only 5% of the total cases entering the court, to both courts, general in civil law, civil cases, as well as family dispute in Sharia, only 5% can be successfully mediated. So it is a bit contradict with the practice in our country, as Pak Samsul mentioned, 70%. Also, when we did comparative study in Australia, 32% of the total annual case entering the court can be mediated, while in Indonesia, only 5%. So a bit contradiction with the values, what we believe. Even in our Pancasila, the principle of state, the principle 4 mentioned that about musyawarah, you mentioned. So I don't know whether Indonesian people have changed their thinking and their values, even among neighbors, among family, brother, sister, in family matters, in business, contract, possible. Finally, come to the court. Even among foundation, religious foundation among the committee, they dispute and finally come or enter the court. So, but the leadership of Supreme Court has never give up in encouraging people. So under our system, Supreme Court, based on the regulation, has the power to issue accreditation to organizations which conduct training. So most mediation office or organizations are established by the private entities. So my question, in Singapore, who established mediator office, whether government or whether a public entity or whether private organization, and whether they have to be paid for their service? And I think also one of the reasons why people, but disputants in Indonesia, are still not willing to choose mediation, because they don't want to pay. They see mediation as charity profession. Well, I think it's different from the US. It's become professional. So mediators, like lawyers, receive fees. But in Indonesia, according to survey, people have not seen yet mediator as full professional which deserve receiving money or receiving fees. They see mediation in the old time practiced by ulama, religious teachers, or the traditional leader, the head of village, or pastoral person, not by professionals who receive money. And the other person, I think, lawyer profession. I think, this is my assumption, most lawyers in Indonesia do not support mediation. They think, we are going to win the case. We don't have to go to mediation. So that's the challenge in Indonesia. So I would see how society in Singapore, yeah, because I read in American publication, mediation also was popularized in North America, but they acknowledge that it comes from the Chinese working immigrant when they went to U.S., building railroad, and the Chinese immigrant in this never go to American court. They settle their own problem. This I read in his book, entitled Dispute Resolution. So, but what happened in Indonesia, I don't know. Even the business association in Kadin, Hamagaga, what is in English, they established mediation. They asked accreditation from Supreme Court. But still many businessmen in Indonesia finally go to the court. I don't know. But, so this is the challenge. Thank you.
Thank you very much, Justice Takdir, for that, if I may say so, excellent observation and a very, very relevant question. You're right. I mean, in a sense, it's counterintuitive. It's contrary to our logic because we all live in societies that historically have valued consensual dispute resolution. When you have quarrels, you get elders to come and talk to you and resolve issues. That's what our historical roots go back. I think that what we have seen in the last couple of 100 years, and I suggested in my remarks that this was probably driven by the colonial legal systems and the colonial legal histories that we all shared, where the emphasis in our colonial legal systems was much more on rights-based adjudication and the focus on giving full effect to who is right and extracting compensation from who is wrong. And that cultural shift which took place over a couple of 100 years probably gave rise to the big issue which Justice Takdir, you identified, which is today we have a professional body, lawyers, who in a sense depend on disputes. They depend on disputes for their livelihood. And I want to digress for a minute just to share an anecdote with you. But I firmly believe that one of the biggest things that will change the picture of dispute resolution is going to be technology, and how technology is going to enable litigants on their own to find outcomes. And this will include things like mediation and online mediation, which I think are trends that will come up in the next few decades. But to come back to your question, so you have the reality that when a person has a legal problem, you can broadly define it in two ways. There are those legal problems which are relatively not going to be worth a legal service, the cost of legal services. A relatively minor amount of money, you don't want to spend a lot of money going to see a lawyer. And for those people, they just give it away. They just write it off. It's called the justice gap. And it is estimated that there are 1 billion, 1.5 billion at least of these problems in the world which just don't get resolved because of the fact that it's too expensive to address it, right? But once you're out of that and the stakes involved in the claim is high enough, people go and see a lawyer. And they get their first input in the case from a legal professional. And the initial view of a legal professional is going to be how do I solve this? How do I win this for my client? Because that's our makeup. That's our makeup from our education, from our training as lawyers. So when we embarked on mediation, now to come to the heart of your question, when we embarked on mediation, we had to engage in an extensive program of education. And the whole point of the education was to reshape the way lawyers think so that their focus is not necessarily on winning every case, but actually their job is to solve the problem for the client. And there are many ways to solve the problem. You know, again, this emphasis on our colonial histories tend to suggest that the only way to solve a legal problem is to go to court and get a victory. But actually, that's not true. And if you can get a good settlement, and a good settlement doesn't mean I get most of what I want, but I get a settlement where I have enough to resolve the issue, I can carry on with my life. If we have an important relationship, we can continue working together. If you get a good settlement, you have solved your problem. And the job of the lawyer is to help the client solve the problem. Sometimes it may be necessary to go to court and fight the case. Sometimes it is not necessary to go to court to fight the case. A lot of the time, a lawyer can help the client solve the problem by finding alternative ways of resolving the dispute. So we had to embark on extensive educational efforts to get lawyers to rethink it. And there were, in broad terms, there were two types of disputes, because in the general commercial area of dispute resolution, the courts were less prescriptive, we were less interventionist. We didn't lay down. We tried to show the benefits of mediation. But in family justice, and that's why I spend so much of time talking about family justice, we directed the reform. And we directed the reform because family justice is a space where the legal system can actually inflict harm on the users. If you don't manage the family justice system properly, your children are going to be victims of the weaponization of the justice system. And as judges who have custodianship, we manage the justice system, we are stewards of the justice system, we have a responsibility to make sure that that collateral damage to children don't happen. So in the last 20 years, last 30 years, and right down to the last 10 years, we have continuously been prescribing and insisting that family justice has to change because we want to avoid harm to innocent victims, the children. There is so much of social science that shows that the biggest harm to children happen when you have acrimonious proceedings between the mother and the father. So that process had to begin, and I personally, together with my colleagues from the bench, I personally went and participated in what we call town hall sessions or dialogues with the family lawyers to explain to them why we have to do this change. And in the beginning, their response was, as you expected, you know, this is going to take away my work, this is going to take away my fees. And my point to them was, disputes are not there to give you fees. Disputes is a necessary part of life, and our job is to solve the disputes in the best way we can. So forget about whether you are going to make more money this way or that way. You will learn to make your money in other ways. So we had to educate them on why we were doing this. And as we went through this process, we started running out training courses, certification courses, accreditation courses to help family lawyers understand that the solution to a family problem is not simply going to court and getting an order. There is sometimes mental health issues. There's sometimes psychological damage to the parties. There's a whole lot of surrounding issues, and we have to approach it together. And then we started reforming our court process where we mandatory included mediation in certain things, and we simplified the process because the second big development that was happening in family justice, which I think is going to happen in other areas, was the emergence of what we call self-represented litigants. These are people who say, the lawyer is costing me too much, I'm going to do it myself. And in family cases, in some areas of family cases, Pak Tadir, as much as 90% of our disputes are dealt with by self-represented persons. So when we had these self-represented persons coming in, we could introduce them to the idea of mediation and say, this is a better way of doing it. We are going to mandate this. We simplified the process. We have developed a whole lot of tools. And the consequence today is, as a rough guide, I think 90% of family cases take up 10% of our resources because it's all resolved in extra judicial setting. But 10% of cases, high conflict, take up 90% of our resources. And those, when we get those cases, they may refuse to mediate for whatever reason. They may refuse to give rise to a settlement through mediation. We actually use multidisciplinary teams to deal with those cases. A judge sits with a social worker and a psychologist together to try to diagnose the issue and figure out how to resolve it. And if they can't, they have to make a decision. They have to make a decision. So education, changing the understanding of the legal profession, working with litigants in process, in self-represented litigants, changing our processes to incorporate mediation, and talking about the value of mediation is all part of re-educating and changing the culture. I think another development that is going to affect this in the commercial space is the cost of litigation. I mean, I mentioned it just now. You know, when I say 10 million, it sounds like a lot of money, but in international disputes, that's not big money. I mean, the cost awards for international arbitration can be in the tens of millions. So I think increasingly parties to commercial disputes will have to think about mediation because it is just not economical. If I'm a board member and my company is involved in a dispute, I will want to know, why aren't we trying mediation? Because that may be a far better and far more, and I don't have to tie up management time for years fighting a case, managing a big case, because a big case is an investment, and I have to tie up my management resource. So I think that's another thing that will drive the change when people start to realize that this is very effective. You asked two other points. One other point, I want to come to that and then deal with a final point. So in Singapore, the mediation is provided by different people. We now have the beginning, the early stages of a full-time professional mediator group. There is at least one senior counsel who was a litigator who's now full-time mediator. He does nothing but mediate cases. And there are a number of other senior lawyers who spend a substantial amount of their time doing mediation work. So that is emerging. A class of professional mediators, that class is emerging. The second point is, we have a range of bodies. Some of them are private mediators. They do it as just their business. But we also have Singapore Mediation Center, which exists under the Singapore Academy of Law, which is semi-private. I am the chair of the Singapore Academy of Law, so it's headed by the judiciary. We have the Singapore International Mediation Center, which is a private body. It was established with the support of the government in 2014. Once it was running, it is a private body, and that does international mediation. We have court-annexed mediation where the judges do mediation, and that is free in the lower courts. That is done for free. There's no charge for the people. And then we also have things like the Law Society's mediation scheme, where they deal with it at nominal cost, very low cost. So we have a range of different modalities by which we deliver. And I think that part of the advantage of having court-annexed mediation is we are exposing people to the benefits of mediation, and actually it is saving our court time. I can give you an example. When we had COVID, we had a number of trials, big heavy trials, which would have taken up a few hundred days in court altogether, that were delayed because of COVID. After the pandemic, the Supreme Court and the Mediation Center did a pro bono project to offer mediation to some of these cases that were held up because of the pandemic. Many of them were settled. And we saved a lot of court time as a result of that. Our judicial resources could be used for other cases. I think courts need to understand that they benefit from mediation because those cases that can be settled well, and it frees up court resources. My last comment I want to share with you is a bit of encouragement. I think my experience is I went to India in 2012 or 2013. India, like Indonesia, like Singapore, has a long history of mediation in its culture and in its society. India, like us, was under British rule for us, under British rule for you, under other Western powers for many, many years. And India also has a very big problem with a backlog of cases. They have many cases that are stuck and are not being resolved. When I went to India, the first time I spoke about mediation in India was in 2013. And it was just beginning. The Delhi High Court had established a mediation center. Here and there, they were establishing a mediation center. And there was a few people who were beginning to look at mediation as a profession. I can tell you, in 10 years, mediation has exploded. It is everywhere now in India. It has been embraced by professional mediators, by courts, the Chief Justice. Everybody now buys into it, and it has grown very rapidly. And I want to offer that as an experience to suggest to you that keep pushing. It's a good cause, and I think you will find that we can persuade people that this is a very good thing to do. Thank you.
Thank you very much. Well, actually, we want to hear more from Chief Justice. Can I just take one more question, if any? Justice Ibrahim, please.
Thank you so much for the moderator. Thank you very much for the remarkable speech of Chief Justice of Sundaris Menon. My question concerning about the enforcement of what the mediator has done. Is there any legal remedy for the disputant party when he or she refused to perform the mediator work? Thank you so much.
Thank you, Justice Ibrahim. So I want to just give two examples very quickly. For domestic mediations, the easiest and most common way in which this is done is when the parties have an agreement. It used to be the case that you'd go to court and have it registered as a consent order, and the order can then be enforced. But in Singapore, we have a Mediation Act. And under the Mediation Act, even domestic agreements can be enforced under the auspices of the Act. And when it is enforced that way, it is enforced as a judgment. And then, more importantly, in the international setting, you have the convention, which similarly allows for mediated settlement agreements to be enforced as judgments of the court once you initiate the process under the convention. And I think this is going to be a very significant development. The two most important developments are the convention and the model law, which I think when it is adopted will give a legal framework for the enforcement of mediated settlement agreements. Justice Ibrahim.
Thank you very much. Again, it's because of time we have to end this productive discussion. But before that, I just want to Is there any real case or success story of international, so far you have it?
So I can tell you the biggest and most well-known case in my view. An example of it was the settlement of a lot of the Nortel claims when Nortel went into bankruptcy. There were hundreds of cases that were successfully mediated using mediation as a framework. And then that was administered in the bankruptcy. That's one example. And in my personal experience as a practitioner, I've dealt with incredibly complex construction disputes that with a good mediator have been able to be resolved within a matter of 2 or 3 days, whereas if you'd gone for arbitration, it may have taken 2 or 3 months and cost 50 times more. So from my personal experience and internationally, there are many, many experiences, I think, that speak to the value of mediation. I think one of the obstacles, going back to Tadir's question, one of the obstacles is that sometimes, again, I think we are shaped by our histories, but we sometimes think it's a question of face. To come and say, I want to talk to you about settling, it's a face, it's showing weakness. But when the court says, we want you to go and try mediation, you don't have to lose face. And then people actually say, yeah, I'd rather settle the case. As a lawyer, my advice to my client was every time the best outcome is settle the case. Better than going to court, because your winning is no guarantee. And the amount of time, cost, and management time it takes up, it's seldom worth it.
It's very good. Well, with that, we have to end this discussion. And once again, thank you very much. Thank you very much for excellent, speech. And of course, we are looking forward to hearing you speak again on other topic, of course. Thank you very much. Then, wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Terima kasih Yang Mulia Ketua Mahkamah Agung Singapura dan Yang Mulia Bapak Syamsul Ma'arif selaku moderator yang telah memandu sesi ini. Boleh kita berikan aplaus Yang Mulia untuk diskusi kita pada hari ini.
Thank you so much, Chief Justice of the Supreme Court of Singapore, Honorable Sundaresh Menon, and also Honorable Justice Syamsul Ma'arif as the moderator for guiding us in this discussion.
Berkenan untuk kembali ke tempat semula. Yang Mulia dan Bapak Ibu hadirin yang kami hormati, sebelum kita menutup dan mengakhiri sesi pada hari ini, marilah kita melaksanakan sesi foto bersama. Mohon izin untuk tetap dalam posisi duduk dan menghadap ke kamera yang berada di depan. Baik Yang Mulia, bersiap.
Honorable ladies and gentlemen, next we will take a group picture. Please remain where you are, remain seated, and face the camera in front of you.
Baik, kami hitung dalam hitungan 3, 2, 1. Sekali lagi. 3, 2, 1. Baik, cukup. Terima kasih. Terima kasih Yang Mulia dan Bapak Ibu yang hari ini kami hormati. Dengan demikian berakhirlah seluruh rangkaian acara pada hari ini. Untuk selanjutnya Yang Mulia para pimpinan Mahkamah Agung Republik Indonesia dan para pimpinan Mahkamah Agung Singapura, kami silakan untuk mengunjungi Museum Mahkamah Agung yang bertempat di lantai 1.
Thank you so much, honorable ladies and gentlemen. That concludes this session this morning. And next, the leadership of the Supreme Court of Indonesia and the leadership of the Supreme Court of Singapore, as well as members of the delegation, are invited to visit the Museum of the Supreme Court on the ground floor.
Dan akhirnya sekian, terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much, and may peace be upon you.